friends, welcome all. So today's topic is all about appointment of an independent director in both unlisted company and listed company. So in this video, I'll walk you all through with the applicability. That means which companies are mandatory required to appoint independent director, what is the number of the independent director required to be appointed as per both Companies Act as well as SEBI LODR, then process part, which will cover the practical way of appointment of an ID in the company listed as well as unlisted, which I have followed while in my employment time. Then in this process, I'll cover each point in detail, so which will help you to practically apply this while making appointment of an ID. Okay, I'll also cover few FAQs which will raised at the time of an appointment of ID, so which will help you to clear your concept. Then maximum directorship allowed, then vacancy to be fulfilled timelines, then DNO insurance, then tenure part, ID meeting requirement, then penalty or consequences in case failure to make appointment of an independent director, and lastly act or section or say regulation references. So be in the video until the end. One more thing, I have also prepared technical videos on various topics like appointment of a company secretary, then appointment of statutory auditor, then SEBI quarterly, half yearly, annual compliances, and so many other topics. And I am also preparing daily knowledge series shorts which will help you to enhance your knowledge as well as brushing your knowledge. So if you haven't subscribed my channel yet, please subscribe it and don't forget to watch the other important videos. So let's start. First, applicability. So which companies are required to mandatorily appoint an independent director? Every listed company. Then every public company. Here the word clearly mentioned in the act is public company. That means other than public company, this is not applicable. For example, for private companies, it is not mandatory to apply an independent director. Okay. Every listed company is required to appoint independent director, and every other public company. Public company having first paid up share capital of 10 crore or more. Then or turnover of 100 crore or more, or outstanding loan, deposit and debentures aggregate of this three is more than or equal to 50 crores on the last date of the financial statement, that is on the 31st March, latest audited financial statement of the available. This data is taken from that financial statement. Then such company is mandatorily required to appoint independent director. Now coming to next, number of independent director. So for the listed company, the criteria is if it depends upon the chairperson. If the company's chairperson is non-executive director, then the 1/3 of the total strength of board should be independent director. Okay. For example, the company is having say 6 director. Okay. Total strength is 6 director. Then 6 into 1/3. So it comes to 2. So 2 should be independent director. Okay. Now in case the chairperson is other than non-executive director, or the chairperson is non-executive director but he is related to promoter, or there is no chairperson in the company. Okay. In all these cases, the requirement is 50%, that is half of the board should be independent director. For example, there is board strength is 7, then comes to half comes to 3.5. So it is converted into next full number, so it comes to 4. So 4 should be independent director in the company. One more thing, if the company is having outstanding superior rights equity shares, in that case also half of the board should be independent director. So this was about the number of independent director. Okay. I'll give you the act or the regulation reference in the last. I'll let you know which section describes what at the last part of the video. Okay. Now coming to this process part. Okay. So if the individual is not having DIN, then first he has to apply for the DIN in the form DIR 3. Okay. But before that he must have DSC for affixing his DSC in the form DRI 3. This is for the person who is not having the DIN number. Now coming to next, if the person is already director or is already having DIN, then you have to collect the documents like first DIR2, that is concerned to act as a director in the company, then his KYC documents, then his photograph, then his profile and qualification details, then disclosures which are mandatory required, that is DIR8 MBP1, then the disclosures of independence as required under section 149 subsection 7 of the Companies Act, and as per the regulation 25, which covers that it fulfills the criteria of regulation 16, because regulation 16 is give definition or meaning of the independent director. So this is for the listed company. Okay, so these are the basic documents which you have to collect before proceeding for his appointment. Now, if the company is mandatorily required to have nomination and remuneration committee. So if the company is mandatorily required to ID, the criteria will be same. Whatever criteria is applicable for ID appointment is same for NRC requirement. That means the criteria of paid up share capital turnover and that outstanding amount of loan, debentures, deposits and listed company. These are required to have to appoint mandatorily appoint ID. The same criteria will apply to NRC. Okay, so if you are mandatorily required to appoint ID, then you must have NRC committee. So it starts from NRC committee. So NRC committee has to evaluate the profile of that person, that is proposed director, and basis on that it recommends to the board for that appointment of an ID. NRC can only recommend, it does not have power to make appointment of the independent director. Okay, here also the director, any director can be only appointed first as an additional director. So he will be appointed as an additional independent director in the board meeting. So next comes to board meeting. So board approves his appointment as an additional independent director. Okay, now coming to next, once this is done, board meeting is conducted. Now in case of listed company, the stock exchange intimation is required. So the timeline is within 12 hours from the conclusion of the board meeting in which appointment of ID is approved. So irrespective of date of his appointment date can be the future date, but the meeting date is important. So within 12 hours of conclusion of that board meeting, the intimation should be made to the stock exchange. This is for the listed company. Okay, I'll give you the reference of the circular in the last part. So this was the timeline for making intimation to stock exchange. Now coming to that next, form filing required. This is applicable for both listed as well as unlisted. So form filing requirement. So DIR12 is required to be filed within a period of 30 days from the date of appointment. Here the date of board meeting is not considered, date of appointment is required. Okay, so within 30 days timeline of date of appointment. Now in that form you have to select appointment, and while selecting that category you have to select additional. Okay, additional, he should be appointed as an additional director, and you have to select the word independent. He cannot be directly appointed as an independent director, he has to be appointed as an additional independent director, because the board has not power, it has to be approved by the shareholders. Okay, so this was about the form filing requirement. Now coming to next, talking about the regularization part. That means every appointment of the director has to be approved by the shareholders for the independent director. So as per the Companies Act, such additional director holds the office until the next annual general meeting. So Companies Act does not require any specific timeline for regularizing the appointment. If it can be regularized in the EGM or until the next AGM. Okay, but in the LODR regulations there is specifically timeline that such appointment, that is within 3 months from that board approves the appointment of ID, such appointment has to be regularized by the shareholders by passing only special resolution within a period of 3 months or in the next general meeting, whichever is earlier. Okay, so this is specifically timeline for the listed company. And the resolution I have mentioned here, whether special resolution or ordinary resolution. So for the unlisted company, appointment of the ID can be approved by the shareholders via passing ordinary resolution, subject to that if the age of the ID is lesser than 70 years. That means if he attains the age of 70 years or more, then special resolution is required for appointment, and in case of reappointment, special resolution is required. This is clearly mentioned in the Companies Act. So for unlisted company, at the time of appointment, if age is less than 70 years, then ordinary resolution is required. But in case of listed company, at the time of appointment or reappointment, that means any director appointment, reappointment time, you must have to pass the special resolution. Okay. So this was the common query which is raised in mind of the person while making ID appointment. So I hope it is clear now. Okay. So this was about the regularization part. Now form filing, again you have to file form MGT 14 and DIR 12. MGT 14 is required to be passed within a period of 30 days from passing the resolution in the shareholders meeting, either general meeting or say annual general meeting. Okay, so MGT 14 is required to be passed, but in case of unlisted company, since you are passing ordinary resolution, then there is no requirement to file form MGT 14. Okay, if SR, that is special resolution, is passed, then you must have to file MGT 14 within 30 days. Now DRI 12, this is applicable to both listed and unlisted. You have to file DRI 12 within 30 days from the regularization of appointment. So in that you have to select the tab change in designation. Okay, so from additional he will be appointed as a director. Independent director will be same, but from additional he will become the normal or say regular director. So DRI 12, 30 days from the date of passing the date of appointment, that means the date where the regularization is made. In that you have to select the change in designation. Okay, so this was about the form filing requirement. Now the requirement are the statutory registers. So you have to update the statutory register for directors and KMP. You have to maintain the entry in that and update the statutory register. Further, you have to update the website of the companies. This is from this first time only. That means you are appointing as an additional independent director within 2 working days. This is the requirement of the LODR regulation. Within 2 working days, you have to update the details of your ID on your website, that is website of the company. So this was the few requirements. One more thing I missed to tell you, that a person who wanted to appointed as an IT or who proposed to be appointed as an ID must have to register himself in the ID data bank, which is maintained by the Indian Institute of Corporate Affairs. Okay, you have to register in that by paying fees. You have to get yourself registered, and if you are not fulfilling the criteria, then you have to also give the examination and pass that examination. Only post that you can be eligible to appointed as an independent director. So this were the few points about the process part. Coming to next, maximum directorship allowed. So here, as per the Companies Act, the person can be appointed as a director in maximum 10 companies, 10 public companies. Okay, here I am only considering public companies because ID is applicable to public companies only. So Companies Act 10, but in case of listed company, LODR regulation requires that a person can appointed as an independent director in maximum 7 companies, 7 listed companies, okay, simultaneously. And in case such director is say whole-time director in that company or say managing director in one listed company, then he can be appointed as an ID in maximum 3 listed companies. Okay, I hope it is clear. So this is the requirement of SEBI LODR regulation. Coming to next, vacancy timeline. So in both Companies Act and LODR, the timeline is at the earliest or within a period of 3 months from the date of vacancy. Okay, so this is the timeline is same, 3 months timeline. Then coming to here the word is written 3 months or next board meeting, whichever is later. So the maximum timeline is 3 months in both listed and unlisted company. Then DNO insurance, this is a benefit, director and officers insurance. This is a benefit for the listed companies. So top 1000 listed companies are required to have the DNO insurance for its independent director. So the terms, condition and the amount of insurance will be decided by the board of directors. Now coming to next, tenure. So ID can be appointed for 2 terms. One term is for 5 years, second term for 5 years. So he can be appointed for maximum period of 10 years and he can be again appointed in that company provided the 3 years time has been passed from his last appointment. Okay, then he can again appointed for 2 terms. Okay, now next, ID meeting. So independent director must have to meet at least once in every financial year, and in such meeting the IDs can only meet, other directors cannot meet. Okay, so next, penalty part or consequences. Okay, so section 172 of the Companies Act provides such penalty in case of failure to comply with this provisions. Then the penalty amount for the company and every person or officer in default, the penalty amount is 50,000 rupees. And in case the failure continues, then the amount of penalty is 500 rupees per day. Maximum amount for the company is 3 lakh rupees, and for officer in default is 1 lakh rupees. Okay, so this was about the penalty or consequences part. Now coming to next, one more FAQ which I came in my mind. Can the CS in employment in another company can be appointed in other company? That means if I am a CS in say ABC Limited, can I appointed as an independent director in say PQR Limited or XYZ Limited? The answer is yes. The CS in whole time employment or the PCS can also appointed as an ID. Subject to that, if the PCS is of ABC Limited, he cannot be appointed in same company as an ID. Okay, so the detailed definition or meaning you can check in Companies Act as well as in LODR regulation, but if it is not related, then you can be appointed as an ID. Okay, coming to next, act reference. So section 149, this provides the part that listed company is required to appoint the independent director. This also describes the timeline, vacancy timeline, that it has to be fulfilled within the period of 3 months. Now coming to next, section 152, this provides that the resolution of shareholders resolution to be passed in the shareholders meeting. Okay, so this prescribes that, this clearly mentions that at the time of reappointment special resolution is required. 161, this is for additional director provision. 178, nomination remuneration committee provisions. 179, board has power, board meeting power. So these are few provisions which are applicable for this particular appointment process. Then rule 4 of companies, appointment and qualification of directors, rule 2014, this describes that which public companies are required to appoint the independent director. The same rule will applicable for constitution of nomination remuneration committee and audit committee. So this is the rule. Then regulation 16, this gives the detailed definition of the word independent director. Regulation regulation 17, this gives the number of directors ID required appointed in the listed company. 17A, this describes the maximum directorship ID can be appointed in companies simultaneously. Regulation 25. Regulation 25 gives that special resolution is required to be passed for every appointment of the director. Okay. This also describes the disclosure part as required, that he fulfills the criteria as prescribed in the regulation 16. So it also gives the declaration part. Regulation 46 is that is website update. That website should be updated within 2 working days. So these are the few LODR regulations. Now this SC intimation, that is stock exchange intimation for appointment of ID. The timeline is within 12 hours of conclusion of board meeting. This comes from SEBI Circular dated July 13, 2023. Okay, so I am mentioning this all act references in the description box, so you can check over that. I have also mentioned this SEBI Circular link in the description box, so you can check that circular from that link on also. I hope it is helpful. If you still have any query regarding this topic or any other topic, or if you wanted me to make any video for any technical topic or other CS student related topic, you can simply write in the comment box. If you have find this video helpful, please like, share and subscribe my channel. Stay connected for more videos. Bye.